discussion of large fire losses. Again, my name is Chris Miller. I'm an attorney with Matthiesen, Wickert Lehrer. This will be a 2-hour program, and it's basically just designed to provide the nuts and bolts that persons in the industry will utilize to investigate large fire loss cases and anything from construction defect kinds of situations, where businesses have burned down, homes have burned down, where automobiles have caught fire and burned down a home around them. Those are the kinds of scenarios that we're dealing with here. We're talking about large fire losses. Most of the insurance policies that we're dealing with here, what kind of coverages are extended to in addressing large fire losses. You have your personal insurance, of course, covers your personal property and health. You'll find those mostly in your homeowners kinds of situations. And you have your home, your auto, and other personal insurance, which would be called upon to satisfy losses caused by fires. In your commercial settings, of course, you have insurance which covers entire buildings and structures, and that's real property. And it also covers the personal property of the business contained within that building. And if there are, for example, other tenants in that building, it could cover potentially losses incurred by other people whose property is stored in that building. Well, we're talking about damages in terms of what is recoverable, okay? Typically, and most of you, of course, all know this, so bear with me if I'm preaching to the choir, shall we say. We have your repair costs, your replacement costs, your actual cash value, your fair market value. Depending what's in your insurance policy, that determines what costs you're responsible for paying as a result of a fire. The actual cash value is typically, strike that. Fair market value is the typical formula you see in most states for what is to be covered as a result of a fire. However, various insurance policies have replacement cost kinds of additions to those policies. Full replacement costs. Again, know what it is that you're dealing with respect to your own insurance policy when you have a particular fire or claim that's been presented. Other potential damages which we're talking about here, and when I describe these damages, these are the things, by the way, that we are seeking to recover as a result of pursuing subrogation in the context of a large fire loss. The repair costs, the replacement costs, the actual cash value, fair market value. You may not be entitled, for example, for replacement costs for damages caused by a fire. For example, Wisconsin fair market value is the typical measure of what you can recover. But in that context, however, you are allowed to account for what it is that is paid and then make a claim against responsible third parties to get what you're allowed to recover as a matter of law. Typically, contents, your personal property or your insured's personal property, most of that is recoverable. Again, it depends on whether it's actual cash value, fair market value, things of that nature. Additional living expenses, those are typically recoverable to one extent or another. Loss of rents, loss of use, business income, these are also typically recoverable, if it's been paid out to your insured as a result of a large fire loss. Okay, let's get on the nuts and bolts of the matter here. Subrogation, this is what we're all talking about here today. All right? When we're talking about subrogation, we're talking about a right which has been conferred upon an insurance carrier, either by law or by contract or by statute, or by common law for that matter, where you essentially stand in the shoes of your insured, and as a result of having paid a claim on behalf of your insured, the insurance company is now entitled to seek reimbursement of whatever money is repaid from responsible third parties. The types of subrogations that we typically deal with in our own situation, again, are contractual. Most of the language that most times in your insurance policies, you're going to find language which confers upon the insurance company the right to subrogate. There's equitable subrogation. For example, it's the common law scenario where, as a matter of, if you have to sue on it as a matter of a tort, because you have basically undertaken, you as the insurance company have undertaken the responsibility of paying a claim on behalf of your insured, equitably speaking, you're allowed to recover against the responsible third party. And then there's statutory subrogation. Typically, you're not going to find an awful lot of statutes or law of that nature in the property and casualty kind of context. More often, you'll find statutory subrogation in the workers' compensation realm, where most states have a formula which conveys upon an insurance company the right to subrogate as a matter of law. The purposes of subrogation, there's a multitude, but the largest one is fairness. The insurance company, obviously, you're in the business of insuring people against losses, catastrophic losses in the case of large fires. However, there's, in terms of fairness, if a third party, whether it be a driver of a car, whether it be a manufacturer of a product, whether it be a subcontractor who installed an electrical socket the wrong way, if they're negligent, and that's what we're talking about here in terms of negligence and tort, okay, and they're the ones who are found to have caused that fire in the first place, you have a right to recover from that responsible third party, because the obvious inference is, why would it be allowed for a person who caused that fire to basically walk away scot-free? Now, there are anti-subrogation arguments. The biggest one you've probably all heard at one point or another would be along the lines of, you're in the business of providing insurance, and insurance companies, by their very nature that is insurance, that's what it is they do. So why should a responsible third party have to pay? That's the most common one I can give to you at this time. Most times, like I stated earlier, when you're dealing with subrogation in the context of an insurance carrier proceeding against a third-party tortfeasor, you're going to find language in your insurance policy that reads something like this: if we pay a claim under your policy, we will take over your right to recover that amount from any other person or organization. You agree to cooperate with us and not to do anything that will interfere with our chances of recovery. That simple clause in there allows you as the insurance carrier to go ahead and seek recovery from other third parties. Simultaneously, the insured is being placed on notice that the rights have been conferred upon the insurance company, number one, and number two, an obligation that they have as insurers to, among other things, receive the benefits of the insurance policy. They have to cooperate with you as the carrier in the inspection and the investigation and the pursuit of subrogation on the insurance carrier's behalf, and they will not do anything to hinder those chances of recovery. Most often what we're talking about in that scenario is where an insured, whether on their own or sometimes with the assistance of counsel they've retained separately, will settle with a third-party tortfeasor for their own uninsured losses and will cut the insurance carrier out of that settlement, okay? And by signing off on a release which indemnifies the tortfeasor from any future exposure to other claims, not the least of which, of course, is the insurance carriers. Now, when we're talking about recognizing subrogation, typically my clients are the kind of folks who are in the business of adjusting claims more often than not, okay? Now, adjusting claims is a process in and of itself in terms of what it is. You have a claim that is presented. You want to ensure that the claim is something that is compensable, and then you want to make sure that the damages that are claimed are fair and reasonable, and that there's obviously a loss which resulted in those losses coming to fruition in any event, okay? Subrogation requires a little broader thinking, if you will. We like to call it the plaintiff's attorney's hat, if you will, all right? The long and the short of it is, you have to, unlike adjusting a claim, where you know exactly what steps must be taken to adjust the claim and make sure your insured is made whole pursuant to the terms of the policy, you now have to think outside the box a little bit in terms of, what is it that I have to do in pursuing subrogation that may allow me and the carrier to go ahead and seek a recovery of whatever money as I pay on my insured's behalf from a responsible third party. It requires training and experience. Training is, it's more like on-the-job training, if you will, and experience is along the same lines. When you see, and many of you, of course, are in the business and have been for years, and I'm sure you've seen many examples where you have a claim that comes in, and there's a fire loss, and there's an allegation of arson, or there's an allegation that a building or a machine backed into a building, or there's an allegation that an electrician miswired a certain circuit in a building. Okay, any one of those three high points, if you will, those flags, should set off alarms saying, well, okay, if an electrician miswired something in this building, is that negligence? And if it is negligence, is that something that's compensable if we can prove that the electrician was negligent in doing his job and basically caused this fire? That's kind of the outside, the next level of thinking that you have to engage in when you're considering and recognizing subrogation on top of whatever claims adjusting that you're doing. Okay, it does require an understanding of tort law. When we're talking about subrogation in fire loss cases, typically we're talking about torts. Someone did something wrong to somebody else and should not have done so. Alrighty. More often than not, it's a negligence kind of allegation. A person had a duty to do something to prevent damage to the property or persons of others, and they breached that duty somehow and caused damages as a result of that breach. Alrighty. Another tort, in fact, is arson, which is an intentional tort. An intentional act by a person or persons who have taken some action to burn down a building or burn down a car or something along those lines. You can recover where there's an arson allegation. However, typically when you're dealing with arson, we're dealing with people who, more often than not, don't have the means to pay any kind of damages that are brought, number one. And number two, it's frequently difficult to prove the intent in any event that there was an intentional act. Regardless, when we're dealing with subrogation, again, you're getting a claim that comes in, you're adjusting that claim from moment one, and that's your first priority. Nevertheless, when you recognize the subrogation, it still requires prompt recognition and prompt action to ensure that the evidence you need, the statements you need to take from witnesses, the artifacts that are causative of the fire are all secured and your investigation is done thoroughly so that you're able, a little bit down the road, to go ahead and make a claim against that third-party tortfeasor and say, hey, listen, we think you caused this fire, and we have all this investigation and background and evidence that shows it. Why don't we talk about settling this thing? Which brings us to our investigation, okay? We're going to cover several topics here: the why to investigate, the how to investigate, the when to investigate, and in our investigation goals, which we can cover right here, okay? First of all, when we're talking about a fire and a losses caused by fire, implicit in that investigation is the fact that fire is a destructive force, meaning that evidence of the fire itself, evidence of what caused the fire, is going to be damaged more likely than not, and sometimes ultimately destroyed, okay? So when we're conducting an investigation of a large fire loss, it is essential that evidence be preserved of whatever it is we believe caused that fire, okay, for two reasons. Number one, we need that evidence to prove our own case as to how a fire started, and number two, to avoid spoliation. Now, we'll cover spoliation in more detail down the road, but the long and the short of it for the moment is that we're talking about spoliation. We have an obligation as the carrier who is in charge of the fire scene, who is responsible for maintaining the fire scene, to allow other parties, whether they be third-party defendants, whether they be other persons or parties who may have lost, have their own claims, separate claims as a result of the fire. We have an obligation to preserve that scene, to allow other people to investigate the scene, to investigate the fire loss, to conduct their own investigation of what happened, okay? And if we do not preserve that fire scene and we do not allow other parties to investigate the cause of the fire, same as we have been given ourselves that opportunity, we can be subject to sanctions. And we'll cover more about that as we get a little closer to spoliation, but the sanctions can include up to dismissal of our lawsuit down the road, okay? Again, our investigation goals, recognizing subrogation we've talked about a little bit already. Identifying key players, targets, and witnesses, okay? When we're talking about our key players, let's use a construction site as an example, alrighty? When we're talking about a construction site and there's a building that's under construction as an example, and a fire burns down the entire building under construction, who are typical key players, okay? Well, if the building is under construction, we're going to want to talk to the architects. We're going to want to talk to the general contractors. We're going to want to talk to the subcontractors, whether they be the plumbers, the electricians, the heating, ventilation, and air conditioning people, okay? we're going to want to identify those players, because all those players, to one degree or another, were probably on site when the fire occurred, or in the hours leading up to that fire. And we want to know who was there, if for no other reason, to see if they know what it was or saw somebody or what it was they did, in terms of how they may play or not play into how this fire started. We also want to identify our targets. Okay, again, using a construction site context, if we have an allegation that this is an electrical fire, well, obviously we're going to want to talk or identify any electricians, subcontractors or otherwise, who were on site at the time of the fire or in the hours or days leading up to the fire, to determine what it was they did and whether what they did was done incorrectly and caused this fire. Obviously, we also want to find out who our witnesses are. Okay. Who are witnesses? Again, they could be any one of the key players we've already discussed: our subcontractors, journeymen, apprentices in the electrical apprentices. It could be anybody. The point is, we have to look into and conduct an investigation into determining what witnesses are available, which may have saw or seen or did or heard people or things, and that are relevant to investigating how this fire started. Coverage issues. Okay, we're talking about arson. Typically, arson is not covered under most policies. Exclusions. Exclusions you'll find, for example, where there's indemnification language in the context of a construction subcontractor's agreement. Okay, you'll find this many, many, many times between a general contractor and a subcontractor, where there's language within their agreement that says, among other things, that I won't sue you, you won't sue me in the event of I am negligent, okay? Or they'll say, if I am sued, you have an obligation to indemnify me and provide me with a defense for any actions that you may have done, or where your work is being questioned, okay? So when we're talking coverage issues, finding out early whether there are exclusions like that, which appears in a construction subcontractor's agreement, is helpful. Because even though it may be a total deal killer and you're no longer allowed to pursue subrogation, at least if you get that language early on in the process of investigating the case, you know what's going on here, and you don't waste your time, effort, and money continuing down a path of investigating a claim, which at the end of the day, you may not be able to go ahead and seek a recovery from a responsible subcontractor. Another goal, of course, is determining damages. What are we talking about here in terms of what was damaged and what is compensable and what is recoverable, all right, as a matter of pursuing a responsible third party in subrogation. Most times, when you're determining damages in the context of adjusting the claim preliminarily, the same kind of analysis that goes into determining coverage, what is covered, what is not coverage in the claim, is also the same kind of analysis which is going to be employed when determining what we can recover through subrogation. Notice issues, excuse me, two things remember here, we'll talk some more about this as time goes on. We're talking notice issues. Number one, is we're back to spoliation. If we have a situation where we think, an electrician, I keep using electrician as the example here just because it's convenient, but in a construction defect setting, for example, who to put on notice of the fire? Honestly, I would put everybody on notice who was on site. All the subcontractors, the general contractor, the architect, the garbage man, anybody who may have been on site in the days or hours or at the time of the fire, I'm going to put on notice of the fire as well, if for no other reason than to give them the opportunity to go ahead and conduct an investigation as much as they want to participate. It could very well be that some of these parties, and maybe even most of these parties, have absolutely nothing to do with the cause of the fire, okay? And at the end of the day, we'll never have any kind of issue, or I will never have any kind of issue pursuing them for subrogation. But at the beginning, when determining notice and who should be put on notice, I believe in doing the shotgun approach, if you will, and set out notices to everybody who might have an interest in the outcome of the investigation, who might have an interest in how this fire started, rather than risk a spoliation argument 6 months, a year down the road because I missed somebody, okay? Second leg of notice issue concerns just situations where you have to put a government entity on notice. In many states and the federal government as well, if you believe you're going to have to put the government on notice of a tort and that you expect them to pay your claim in subrogation, you have a certain time period to provide them with notice of your claim. All right? In Wisconsin, it's 120 days. All righty? When you have to do that, and it's usually by statute, you have to provide them with a formal notice, and in Wisconsin, like most other states, there's actually a particular way of going about doing it, okay? You have to provide them with notice of your claim to give this government entity an opportunity, a formal opportunity, if you will, to investigate your claim and how it began. If you do not provide them with a notice of your claim pursuant to whatever statute is applicable, more often than not, you are barred from pursuing damages against that government entity in the future. Okay? One final investigation goal is to eliminate alternate causes of the loss. Trust me when I say that when you put all these parties on notice of your claim and that you're giving them an opportunity to inspect the loss with you, all of them are going to be looking for any and all potential causes for this loss. I'll give you an example here. Let's say you're using our construction defect example again, and we'll use our electrician again. Our electrician, he miswired an electrical light socket, okay, and it shorted out and caused this building to burn down, okay. Well, we'll get the plumber in there, we'll get the electrician in there, we'll get the general contractor in there, okay, and they'll have their experts there, and all their experts will be looking at what it is we think caused the fire, but they'll also be looking at other potential causes for the fire. For example, was there a dumpster parked in close proximity to the building, and were people, did the dumpster in some way, shape, or form look like the fire originated from that dumpster? Were there cigarette butts all around in the vicinity of where this electrical outlet was? Okay, who was smoking on site, and how many? And do they smoke on a regular basis? And why is it the practice of the general contractor to allow persons to smoke on the job site? Okay, they'll be looking for any and all issues they can come up with to try to dilute what you claim to be as your cause and your origin for this fire. So, when you're conducting your own investigation goals, you're looking at those same other potential causes for the fire, if for no other reason than to mute or otherwise blunt the arguments that you're sure these other parties are going to make down the road. Okay, now I apologize in advance here. There's two slides that you did not have on your sheets in front of you. This is one of them, the why, and then the next one is the how. For some reason, they did not make it into our PowerPoint when it was sent out earlier this week. I will be happy, anybody who wants these two next slides, the why and the how, I would have to email those to you so you can complete your PowerPoint at the conclusion of our webinar here today. Okay. Meanwhile, here's how we go about our investigation. The why. Okay. What we're trying to accomplish when we go ahead and conduct our investigation. Because you are, the carrier, because your insured has control of the building, we'll say, as an example, you have the first chance at all evidence. You control the scene, okay? You have the ability to basically dictate who gets there first and how to go about preserving what needs to be preserved, okay? From the outset, you are the driving force between, at that point, for everybody else, everything else that follows in terms of conducting an investigation, preserving the fire scene, preserving evidence that indicates what the cause and origin of the fire is all about. Because you're first on scene and you're getting the first chance of evidence, you get to identify and retain that evidence too. In fact, you have an obligation to do that, again, to avoid a spoliation argument. So, getting in on the investigation early is paramount. Those first two reasons are the best reasons I can give you. Evidence is everything in a fire loss case. Without physical evidence, more often than not, you don't have much of a case. Catching witnesses when memories are fresh. The human mind is a wonderful thing, and it is the most powerful computer ever conceived. However, it is ultimately flawed. What I mean by that essentially is that if you have a witness who saw something, heard something, did something, all right, and that witness is asked to testify on what it is he saw, heard, or did 2 years later in the middle of a jury trial, my experience has been that more often than not, that person will not make a good witness because 2 years is a long time to retain the details of the who, the what, the where, the when, and the how of what went on at a fire scene 2 years prior, okay? So early on, identifying your witnesses and catching them when their memories are fresh, right after the event happens, and then lock him into positions of testimony with a witness statement, a recorded statement, a video statement. Okay, any one of those three things is very, very, very helpful, because 2 years down the road, when that witness is testifying in the witness stand and can't recall whether the sky was gray or whether it was a blue sky, sunny or warm or what have you, they can look at their witness statement, or they can listen to their own recorded statement, and it refreshes their memory, and it allows them to remember what happened in more clarity and more detail, and makes them better witnesses all around. Also, there are the odd times when some witnesses disappear for whatever reason. Okay, maybe they die, maybe they move away, we can't find them. Okay, there are times when a witness statement, a recorded witness statement, can be used in court even though that witness is no longer available. Identifying roadblocks. We've talked a little bit about this already. We'll talk some more about it in the future, but more often than not, you're going to see the roadblocks we're talking about here in terms of an indemnity and waiver. Again, more often than not in the construction defect kind of setting. Okay, and the best reason to go ahead and get, for example, your subcontractor's agreement early on, assuming your subcontractor is the insured. If there is, in fact, indemnity language within that subcontractor's agreement or waiver language, again, at least you know early on in the investigation, so that if it does ultimately result in a situation where you're no longer allowed to subrogate because of that indemnity language or that waiver language, at least you know early on, and you're not wasting your time, your money, you're not spinning your wheels, if you will, okay, conducting an investigation which ultimately you cannot pursue against the responsible third party but for that language. When this is essentially a walkthrough of your subrogation lawsuit, okay? Keep in mind here, we're talking about a fire loss case. This hinges largely on evidence collected and more often than not expert witnesses, okay? What you're doing in the course of your investigation is basically building up or filling in the pieces or creating a puzzle, call it what you want to call it, okay, that allows your case to be crafted in such a way that's presentable to a jury or another fact finder down the road, so that that fact finder can understand what happened and why it happened, and that another person was at fault for this fire, and that you were allowed to make a recovery and subrogation as a result of that person's fault. Okay. Identifying all possible third parties, again, that's paramount and should be done as early as possible. And sometimes you can't identify all third parties at the outset of an investigation, especially in the fire loss case. Like I said, more often than not, evidence of the loss, of what caused the loss, is frequently damaged, sometimes burned beyond all recognition, and you run into situations where, while you're able to identify, say, a manufacturer of a plug, okay, but the plug is comprised of 3 or 4 or 5 other different components, which each one of those is built by another manufacturer, okay? And down the road, you have an inspection with the manufacturer of the plug, but as you get into that plug by way of destructive testing and destructive inspection, you discover that we believe the cause of the fire was another manufacturer of a component in that plug. Basically, you have to put everything on hold and then put that next manufacturer on notice of the claim as well. The point is that we didn't know there was another party which had to be put on notice until we got beyond, for example, the initial site inspection with all parties present that we knew about, the subsequent destructive testing and inspection of the plug with all parties that we then knew about, okay? But what is important is that once you discover there is additional parties that need to be put on notice once you got into your destructive testing, you need to put those parties on notice. But before you get there, you have to stop what it is that you're doing in terms of destructive testing and destructive inspections, because they can then, again, that new party, if you will, can make a spoliation argument down the road. Also, as far as why is concerned, it prevents insurance fraud. I know in the last 2 years, in fire loss cases, arson is way up. Arson is probably the biggest leading cause of fires at this point in time, more so than negligence, more so than product liability. So when you investigate a case in a fire loss case, you're pretty much doing the same things that you would do when investigating subrogation in the context of arson. you're still going to go ahead and get your witnesses. You're still going to find out what the cause of the fire is. You're still going to employ an expert to determine what the cause of the fire is. The end result, however, is if you have a fraud situation where someone commits arson to defraud you as the insurance carrier, well, at least you know through your expert that, you know, maybe a person lit his building on fire using a flammable substance. Okay. Yes, it makes it next to impossible to make any kind of recovery in subrogation, but then again, now you have grounds to deny the claim too. So, and you want to be very clear and very careful if you ever feel the need to deny a claim, because then again, you could also be looking at a potential bad faith claim if you're wrong. So the investigation and the why of the investigation is very important in that respect as well. Okay, now the what. Here's what we're looking for. Here's what we're after as far as the details of how the fire started and what happened. Okay, we're looking into the facts and details surrounding the injury or death. I apologize, should be the fire loss. And again, this is the what here is the second slide, which is not included with your PowerPoint. Again, I will forward this to you along with the why slide if anybody has a request to do so. Okay. Anyway, look into the facts and details surrounding the fire. Okay, that is obviously the most important goal and the most immediate goal of what it is that you're doing as far as investigating the fire is concerned. Okay, because without the facts and the details, the evidence to back it up, you can't go forward with subrogation. It's a valuable commodity that can be used to our advantage. Again, keep in mind here, you as the carrier, you are the first persons on the scene. Your field adjusters, your in-house adjusters, plus your experts, they're the ones who are doing the initial legwork and then control the whole darn investigation once other parties have been put on notice. Okay? What I mean by the valuable commodity is, suppose you have a situation where your insured has a ton of uninsured losses of his or her own. Okay, and that insured has hired their own attorney for purposes of representing them to recover those uninsured losses. All right, that attorney will typically come to the party late. Okay, and will not have been, part of the initial investigation. Will not have been part of the initial discussion of what to look for and the cause and origin. Will not have been able to have hired their own experts to investigate the actual fire scene, things of that nature. All right, you have all that. You have experts. You have your witness statements. You can use all that stuff that you have and basically say to that plaintiff's attorney, how you want to phrase it, but I can provide you with all this sort of thing, but you have to do things like protect our lien, okay? Or you take lead in prosecuting the case, and then and we'll take our recovery at the settlement or the jury verdict based upon what it is you recover, okay? The idea is to reduce costs for you, okay, and reduce the or increase your ability to make a recovery by using the plaintiff's attorney or the insurance attorney for that purpose. Information and product or instrumentality causing the loss. Excuse me. What you want, when you have a situation where we're dealing with a product liability case, we're accusing a manufacturer that their product caused a fire. Okay. Obviously, what you're going to want to have is any information that you can get your hands on that describes the product, what it does, how old it is, what its history is in terms of production. Okay, the first place you go about getting that information is from your insured. All right. For example, if you have a situation where a construction heater is being used by your subcontractor insured, and that construction heater is owned by your subcontractor insured, the first thing I'm going to ask of my subcontractor insured person, point of contact, is I need your instruction manual. I need your warnings. I need your maintenance and repair invoices and sheets of that nature on this particular product. Okay. Hopefully they maintain records like that. But the point is, in that documentation, the instruction manual, the owner's manual, okay, the maintenance records, you don't know what you're going to find, but you hope to find things like maybe this particular construction heater had been worked on and repaired less than 10 days prior to the fire, and it was repaired by repairing a gas line that had been leaking. Well, the next obvious question is, well, was the leak actually repaired? Did that repair company actually make the leak go away, or was the leak still there after it was supposedly repaired, and that's what caused the fire? That's the kind of thinking that goes into the whole putting a plaintiff's hat on, okay, and expanding your thought process as far as what do I have to do to make a recovery in subrogation. A defense to combat claims for attorney's fees and costs. This is not so much a factor in the property and casualty realm. It's more of a situation you might find in workers' compensation. Not to say it doesn't happen in property and casualty, because it does, but using workers' comp as an example, most workers' comp statutes in whatever state you're dealing with here allow for an attorney, frequently who represents the injured, insured or worker, to recover a chunk of their fees directly from whatever it is the insurance company paid out as far as their subrogation is concerned. Okay, the defense to that is that the insurance company was forced to or did retain their own carrier, their own attorney, to basically represent their own interest in the lawsuit or represent their own interest in investigating and proving up the claim of liability. Okay, and where in that situation where a plaintiff's attorney might say, well, I'm entitled to a third of the total recovery that this insurance carrier makes as a result of my work because I did all the work, you can come back to that judge and say, no, judge, we did our own work to prove up liability. In fact, it was our work that let the plaintiff's counsel prove his case of liability against the third-party tortfeasor at trial. Therefore, he shouldn't get his whole 1/3 fees from our recovery. It should be prorated, or it should be trickled down in some fashion where he gets maybe 15%, something along those lines. Okay. It's a means to uncover several killers such as indemnity and waiver. We've already talked about that. It's a protection against the disappearing witnesses and evidence. Again, we talked about the disappearing witnesses situation. Putting witnesses that you can identify as early as possible and putting them on the record by way of a recorded statement or a written statement, very, 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 very helpful in terms of, again, protecting against disappearing witnesses, because witnesses do disappear and they cannot be found. Despite our modern age of the internet and what have you, and using private investigators, sometimes a key witness just cannot be found. And if we have them on tape, or if we have a written statement from them, as long as there is an exception to the hearsay rule, we can get that statement in to be considered by the jury sometimes. Evidence, same thing. Without evidence in a fire loss case, what is the instrumentality of the fire? Highly unlikely we'll be able to prove our case down the road as far as the loss is concerned. Chance to get information before the employee. Again, I apologize. This should have been the insured before he is represented. In that scenario here, we have an insured who is already obligated to cooperate with you anyway by virtue of the language in the policy. Okay, but we all know the term lawyered up. When an insured person believes that he or she must get their own attorney to represent their own uninsured interests, we all know it becomes an awful lot more difficult to communicate with that insured as far as adjusting the claim on through what happened, what happened statement or taking their statement. So again, you have the first opportunity to speak with the insured with respect to the what happened and the how it happened and why it happened, and you get to put them on tape or record them too at the very, very outset of the investigation. Let's see, a tool to bring extraterritorial issues into play. We'll talk more about that a little later on. Opportunity to represent plaintiff's interests. Plaintiff in this case, of course, is our insured. All right, and particularly in Wisconsin, where I do most of my practice, when we bring a lawsuit in a subrogation claim on behalf of a third part of an insurance carrier, we're required, pursuant to civil procedure rules, to bring all parties into that case who may have an interest in the outcome of that case. And what I mean by all parties is, in addition to all third-party defendants who may have contributed to the loss and the cause of the fire, we're also obligated to bring in the insured as well for any claims they may not have which were not covered by insurance. More often than not, it's simply just their deductible, whether it be $500 or $1,000. Sometimes that insured is underinsured, and they have much larger losses. Either way, it is an opportunity to represent their interests as much as it is yours, because you all have to prove the same degree of liability. More often than not, when we're going after a party in a fire loss case, it's because they have enough assets or enough insurance to satisfy all claims brought by us as well as the insured. So At the end of the day, what you get in terms of an advantage is a situation where, because you represent the insured as well as we represent the insured as well as the carrier, okay, we get to control access to that insured by the other eventual attorneys for the third-party defendants in the case. Opportunity to recover third parties, uncover third parties and sources of recovery. We've covered a little bit about discovering third parties and who might be on the hook for a loss. Others, we'll cover some more about that a little later on. Other sources of recovery. Again, most of my practice is in Wisconsin, and when I think of other sources of recovery here, frequently what I'm talking about is a secondary insurance. You have your primary, of course. We all know, more often than not, the primary insurance carrier is going to handle most of the load as far as satisfying any loss. But in Wisconsin, because we're required to name any interested parties as pursuant to the court procedure rules, who may have an interest in the case or may be liable in a case, we also have to identify secondary sources of insurance too, and frequently name them in a complaint as well. Okay, and the how. The how is also missing from your PowerPoint presentation as well. The tools of the trade, this is what we're talking about. We're talking about the how, okay? Statements and recordings, we've already talked a bit about that, okay, in terms of what it is we're trying to accomplish by identifying our witnesses and getting them on the record. Now, let me say something about witnesses here in terms of statements and recordings. What I encourage my clients to do, because they're the ones who typically take the recorded statement over the telephone more often than not, is not to simply ask the person you're talking to, hey, you were at this place at this time and you saw the fire. Okay, tell me what happened. What you get when you ask a tell me what happened kind of open-ended question is a 2 to 3 line paragraph blurb, if you will, soundbite, if you want to call it in our super duper technology communication age. It doesn't tell you much of anything. Okay, you'll get a statement something along the lines of, well, I was here at this location and I saw the fire break out and it took down this building and that building, and I saw the fire department come and they put the fire out. Very general, doesn't tell you much of anything. Okay, what I would encourage my clients to do is to, when you take a recorded statement of a witness in a case, have a checklist of questions, specific questions that you want to ask that are designed to get answers about the who, the what, the where, the when, the how, and the why of what happened. Okay, and just a witness who's standing by and watches the fire department come by and put the fire out is not going to be helpful if he just says that. Now, if that same witness who's standing at the same location is asked questions like, well, where were you when you were standing next to the fire? Well, I was 10, 15 feet away from where the fire broke out. And where did the fire break out? Well, it broke out at the northeast corner of this particular building. And did you see anything at that northeast corner of the building that struck you as kind of funny or unusual as for why the fire broke out there? Well, I saw 2 guys who were sitting there doing something with a gas, it looked like a gas can to me about 20 minutes earlier. Okay, well, what those 2 guys look like? Well, they look like X, Y, and Z and what have you. You see my point. The questions that you ask will frequently lead to answers which will allow you to ask additional questions. And the idea is, by asking more questions, rather than just letting your witness just state a blurb, get you an awful lot more information about what it is he saw or she saw, heard, did, and it frequently will lead you down another route to go ahead and investigate how a fire started. Photographs. We've all heard the terms, a photograph says 1,000 words. No truer words were ever spoken. Early photographs of the fire scene while the fire is burning are fantastic. We almost never get them. Frequently, if we get photographs like that, it's usually taken by somebody from the fire department. More often than not, however, we get photographs that are taken by our field adjusters or our expert witnesses. Okay, experts should be taking a gazillion photographs regardless of what kind of fire scene it is, because that's primarily what it is they do. And like I said, photographs, I can't tell you how many times I've been in trial where I have taken a photograph taken by an expert or a field adjuster to make a specific point in my argument, and I'll blow that photograph up to a 3 foot by 5 foot poster, make it all glossy, and I will refer to that photograph over and over and over again to the jury to strike my point home that this photograph and what's on it is the key to this case. And I'll leave that poster hanging out there through the course of the whole trial so that the jury can always be reminded to come back to that message I'm trying to send by putting that photograph in front of them. Preserving evidence we've already talked about. We'll talk some more about that in the context of experts. Observing witnesses. Now, observing witnesses is going to be difficult to do over the telephone. That much is certainly true. But those of you who may be field adjusters or who rely upon field adjusters to talk to witnesses and take statements at the scene, one of the things I would encourage those field adjusters to do is to observe the witness, the person that you're talking to. Okay? How do they present themselves? How do they speak? Do they look like they're nervous? Do they look like they're trying to hide something? We're all students of human nature to one degree or another. We all have suspicions about if someone's trying to avoid talking to you or maybe lying to you. Okay? We all have visual cues, whether you want to acknowledge them or not, that tell you that, well, maybe this person would not make such a good witness for us at a trial down the road. Okay? So observing a witness and making notations on those observations about, hey, how this guy seemed he wouldn't look me dead in the eye, and his questions were kind of, or his answers were kind of forced, and he looked like he was searching for an answer to a question, this question or that question. Those are observations that are good for someone like me who has to look at this witness statement 6 months later on and go, maybe I want to have a second look at this witness to see if it's somebody I want to use or put in front of a jury. Taking measurements. Taking measurements is more your expert's role in a fire loss case. We'll talk some more about that. Obtaining documents and reports. We've talked some about that. Documents that I would like to see, for example, in a construction defect kind of case. Again, the first thing I want is the subcontractor's agreement. The next thing I want is the architectural drawings. And the third thing I want are all the documents which indicate who, in terms of the subcontractors and contractors, anybody else for that matter, who was present on the construction site at the time of the fire or the days leading up to the fire. Okay? Reports. The reports we're talking about here are your fire department reports and your police reports. Okay? I'm sure you all know how to get those. The fastest way to get any information of any kind about a fire, short of having done the work yourself, is to get it from the fire department. The fire department reports are not generally conclusive unless there's some compelling reason for why the fire department undertook a specific investigation of a fire, for example, arson. They're investigating an allegation of arson, okay? But they do frequently give you the very basic answers to the who, the what, the where, the when, and the how, all right? Maybe not so much the how, but the who, the what, the when, and the where, all right? And you can frequently find out additional witnesses you may not have known about, but that the fire department did discover, and they're listed in that report. Okay, same goes for police reports as well. Oh, excuse me. In some cases, formal investigations are conducted by the federal government, the Bureau of Alcohol, Tobacco, and Firearms. If you get the ATF involved, the ATF is involved in the case, then there is going to be an arson type of claim. And frequently the situation you run into there is that the ATF, they will tend to take charge of the fire scene regardless of what your interest is, regardless if you insure the whole building or not. The ATF has a habit of basically issuing a decree saying, we're in charge of the fire scene, and maybe if you're lucky, we won't level the place before you all get a chance to look at this thing too. So if that is a situation that you have to deal with, you're dealing with the ATF or some other federal portion of the government, or even the state government, investigating an arson claim, among others, frequently what you get is a situation where the only report that summarizes an investigation of the fire scene is that which is produced by the ATF or the Fire Marshal's Bureau in Wisconsin. Engaging experts. We're going to talk a lot more about this in a few minutes, but basically, when you're talking about a fire, you're talking about the need to hire experts, okay? Specifically, starting with an origin and cause expert or cause and origin. I still call them cause and origin experts, but the origin and cause experts like to be called origin and cause experts. That's the first expert you're going to want to hire, and the whole purpose of the origin and cause expert really is to investigate the origin of the fire. based upon what that expert does or finds, will frequently lead to the retention of additional experts, usually in the form of electrical or mechanical engineers of one type or another, who can opine with respect to the actual cause of the fire and how the methodology behind how the fire actually started. Giving proper notice, we talked about that already. We'll probably talk a little bit more about that in the future. Coming to conclusions, writing summaries and recommendations, and engaging subrogation counsel. We're going to cover all these three in one fell swoop, okay? Basically, you have done the investigation. You have found out who was there, the witnesses, got your recordings all lined up, got your evidence preserved, got your experts with opinions in hand, okay? But no reports. We'll talk some more about that too. All right, what do you do next? Well, coming to conclusions, obviously, if you believe there's something out there that needs to be looked at and subrogation is possible, okay, you want to go ahead and take the next step, and that is write your own summary recommendations for the file. Okay, so you're stating exactly what it is that you believe is the basis for your subrogation claim, but then engage subrogation counsel, someone like myself. All right, and the purpose for engaging subrogation counsel is to run your investigation results, your recommendations, your conclusions by that subrogation counsel, and determine if, in fact, you have enough here to go ahead and seek a recovery against a responsible third party in court, in litigation. Okay? Now, one thing on subrogation counsel, this occurs, it says engaging subrogation counsel at the conclusion of this slide and the conclusion of the other two slides too. It suggests that engaging subrogation counsel is something that happens late in the game after your investigation is largely concluded. In fact, I do encourage my clients to engage subrogation counsel, at least on some level, early on in the process, okay? You don't have to do a formal engagement, by way of I'm going to represent or have that attorney formally represent you in the investigation of the matter, though I would prefer that. But at least call subrogation counsel as you're starting an investigation if you suspect that subrogation is possible, okay? And the reason you want to talk to a subrogation attorney early on in the process is because that attorney is going to know what is going to be necessary for you to discover, you to investigate, you to gather in terms of evidence and witnesses and recordings and reports and what have you. That attorney is going to know what he or she is going to need to prove your case in court in front of a jury, okay? And you can bounce ideas off of or ask questions of that subrogation counsel without even retaining them at that time, saying, hey, listen, I got this fire case, it's on a construction scene, all right, I'm about to start investigating here. What do you think I need to be gathering up for you so when I refer this case to you, you have an easier time of proving your case in court, okay? So the point of the story is I would recommend engaging subrogation counsel on some level early on rather than late on in the investigation process, all right? Okay, now, large loss property subrogation, okay? We're talking fires. Fires, of course, are destructive, and they frequently would destroy or damage a lot of evidence, a lot of building, a lot of property, okay? We are going to need an expert witness immediately. I've already talked a little bit about that, okay? But the first thing to do, my recommendation would be to hire an origin and cause expert, okay? Again, an engineer or surveyor, et cetera, those folks will typically come after you've hired your origin and cause expert, because that origin and cause expert, if they're good, will investigate, at least preliminarily, the fire scene, determine where the origin of the fire was, will have conducted his or her own investigation with respect to questioning witnesses, getting an idea, looking at reports from police and fire, getting an idea of what might be the theory of a fire, cause for the fire, okay? And then based upon that cause and origin experts' work and their subsequent recommendation, then you may want to go ahead and hire additional experts in the form of electrical engineers or mechanical engineers, surveyors, what have you, that are going to go ahead and firm up or actually provide you with an opinion as to how the fire was caused, okay? Obtain all reports, we talked about that already. Talking to a fire marshal and police investigator. Now, looking at reports is one thing, and like I stated earlier, looking at a police report or a fire report, generally speaking, my experience has been, is not going to be all that conclusive with respect to, the absolute, this is what the cause of the fire is, and here's how we know that. Sometimes you get that, most times you don't, okay? However, most fire marshals or police investigators are investigators because they've been in the business for a while. They've been trained to do an investigation, okay? They are experienced in what to look for, and they're experienced to calculate hunches, if nothing else, okay? Maybe they don't have enough to go ahead and prove a crime, which is what they're actually drafting reports for. They're investigating the possibility that a crime had been committed, okay? You, as a carrier, are not interested so much in whether a crime had been committed. You're just interested in what the cause of the fire was, okay? And whether the cause of that fire was caused by a responsible third party, regardless of whether it was intentional or just an act of negligence, an accident, if you will, okay? When you talk to the fire marshal or talk to the police investigator and have their reports in front of you, you have the ability to ask those investigators, hey, listen, your report basically excludes the possibility that this is an arson case, all right? But you've been doing this a while. What do you think the fire started? Why do you think the fire started? And frequently what you get is, if nothing else, an off-the-record commentary from that fire marshal of, well, there's no arson here. I mean, there's no poured accelerant, no gasoline lying where it shouldn't be, no evidence of, explosive devices, okay? But then again, I did observe that the majority of the V patterns showing where the fire really started, okay, came out of this, this floor heater in the corner of this room, okay, and they'll just tell you that, and it may not appear in their report in any kind of great detail because it doesn't need to be, because all they're doing is investigating whether a crime had been committed or not. But these guys have more than enough training, more than enough knowledge and training and experience that when you talk to them, they will frequently give you insight into, while they may not be evidence of a crime, they may have some ideas about what they do think did start the fire or where its origin was, if nothing else. Okay? Obtaining names and of all potential witnesses. We've already talked a little bit about that, but I can't emphasize enough that getting your witnesses and getting all potential witnesses in a list is exceedingly helpful. And more often than not, the fire marshal and the police investigator will have some indications on who's important in their eyes as well. Obtaining all contracts, again, we've talked a little bit about that. We're talking about in the context of construction defect cases where it's alleged that a subcontractor or a contractor did something wrong and caused this fire, but they're subject to the terms and conditions of the subcontractor's agreement. Consider a private investigator. Well, private investigators do serve their purposes. I use them more often than not to find people. That's usually where I come across having the need to use a private investigator. So if you have a witness, for example, who's all but disappeared for whatever reason, using a PI to try to track that witness down is where I most frequently use them. Private investigators are not going to be so helpful, but they won't be helpful in the context of actually investigating the fire itself and the causes for that fire. Okay? Goals of defense, we've already talked a little about that too. They are looking for alternate causes to the fire. They're trying, defense counsel for third-party people, and they're experts too. While all experts will claim to be impartial and dispassionate about who it is that retain them or what it is they're doing, let's be honest here. Some good experts are retained by defense counsel for a reason, and some experts are retained by plaintiff's counsel for a reason. Okay, and defense counsel's experts, well, they're looking for as many other possible alternate causes for the fire, if for no other reason than to shoot arrows at your own theory of the case, where it is we say that this fire started because of one specific reason or another. Also, they're looking for spoliation too. Okay, spoliation, again, we'll talk a little more about, but the long story short here is if a defense expert and defense counsel believes that in some way, shape, or form their clients were not given the opportunity and should have been to investigate the fire and the causes for that fire to their heart's content, they will make a spoliation claim in the course of ongoing litigation with the goal of trying to dismiss your claim down the road. All right? Okay, now we get into some specific causes for these large loss fires. My favorite is product liability. This is most of what I do in my own practice. when we're dealing with products liability, we are dealing with a situation where a product, whether it be a car, a heater, an iron, stove, an air conditioner, a telephone, a computer, whatever the case may be, okay, we're dealing with a product which for whatever reason failed and caused the fire as a result, okay? We're looking at the reason for why a product failed. We're looking at one of the three main causes, whether there was a design defect in that product, meaning that the whole line of products is defective by virtue of whatever is going on in the design of that product, whether there was a manufacturing defect, more often not in that one product that we think caused the fire as opposed to a whole line of products, okay, that's more often not when you see it, or a marketing defect, meaning that this product is inherently dangerous and defective, okay, but it didn't have appropriate warnings or was marketed to persons for use in a particular way that it should not have been marketed to, and the use in that particular way caused this fire to occur, okay? That's what you're looking for primarily, one of those three things or a combination of all those three things when you're proving a claim for product liability. Paramount in any product liability case is to identify and preserve that product. If you identify the product but fail to preserve it for whatever reason, okay, and don't give other parties an opportunity to investigate that product themselves, don't save it for litigation down the road. More often than not, I don't think I've ever heard of a situation where you will be able to prevail in litigation without having preserved that product in the first place. So, in any fire case where the product is suspected of having caused the loss, that product must be preserved and it must be kept according to a chain of custody, meaning that there has to be a line of possession showing where and when and by whom that product was saved or taken out of the fire scene, okay? And then from that point going forward, who had possession of that product, what they did with it up to the time it actually presents itself or you use it at trial, okay? All right, now the defects we're talking about here. A manufacturing defect, when the product bends, breaks, fails, leaks, ignites, explodes, or does something different other than what it was designed to do, okay? You see that there's a dryer there in that picture in the upper right-hand corner. First of all, I don't know what that specific dryer was wrong with it, okay? But what it's safe to assume is that dryer is one of a long line of dryers all produced off the same assembly line, okay? And if we're talking about a manufacturer's defect, what we're looking for if that dryer is something specific to this particular machine, okay, which caused a fire, all right? In the context of this dryer, maybe there was a bad electrical connection in the power cord, all right? Or maybe there was a situation where the lint trap, this is a gas-fired dryer, okay, and the lint trap, which is designed to take the lint from the clothes that are being dried outside of that dryer itself, for whatever reason decided to start feeding lint towards the open flame that heated the dryer in the first place. And that lint is what ultimately caused that fire. So, you know, why is there lint escaping from the lint trap to the open flame is a question that you're looking for in terms of a manufacturer's defect, okay? A design defect, this is where a product does conform to its plans, its specifications, its design, but the actual design itself renders the product unreasonably dangerous. Now, many times products, by their very nature, are unreasonably dangerous. Or I should say they're defective and dangerous, maybe not unreasonably so. For example, a gun, by its very nature, is a dangerous product, okay? But a gun, we all know, is designed to be that way, okay? Where we run into situations about a design defect where we have a product which is inherently dangerous and defective, and unreasonably so, might be a situation where a product has all sorts of moving parts on it, but they don't have appropriate guards around those moving parts to prevent an operator from errantly putting his hand or her hand in close proximity to those moving parts to the extent that a hand can be injured or damaged, okay? So we're talking about an unreasonably dangerous situation. It could be something as simple as that where the design itself is dangerous, but because it's unreasonably dangerous because while the design itself is dangerous, you can take steps as the manufacturer to minimize the exposure to risk of property and limb by taking like a guarding situation. A marketing defect is just as actionable as is a design or manufacturing defect. Now, I frequently have a hard time convincing my clients that, in fact, a marketing defect is a defect just like a design defect or a manufacturer's defect. And the reason for that is it's sometimes hard to get your mind wrapped around the idea that where a product does not offer appropriate instructions for how to use that product, or a product which is dangerous, okay, and can't be fixed, okay, or guarded to prevent the risk of harm to property and persons, therefore there should be an appropriate warning sticker or label attached to it, okay? That is just as much a defect as anything else, all right? But long and the short of it is that that's a situation where the manufacturer and the seller fail to warn of the product's dangers, okay, or to provide instructions for safe use of that product, and as a result of having failed to have provided those warnings to would-be users, okay, excuse me, this fire was the result. Okay, so when you're conducting your investigation, all right, you're looking for one of the three things: design, manufacturing, defect, or warning. First thing to remember here is that when you're trying to prove a product liability case, a claim, you must have an expert, okay? You cannot prove that a product is defective and inherently dangerous, and unreasonably so, without an expert opinion saying as much, okay? In the context of a fire loss case, all right, your cause and origin person is typically not going to be the kind of expert you need to provide an opinion with respect to how this product was defective, okay? You're typically going to require the services of an electrical engineer, mechanical engineer, whatever engineer that you might need to prove that this product was defective and why, okay? Obtaining, securing, and packaging the product. Once you've identified that a product is the cause of the fire, all right, you're going to want to, again, preserve it, because without it, you won't be able to prove your case down the road. So you're already using your experts anyway. Any expert who is worth hiring in the first place is going to know that he's going to have to retain that product, okay, as evidence in the case itself, if for no other reason than to prove his own theory of the case as to what his opinions are with respect to cause, okay? So what needs to happen is once that product's been secured and identified, once all parties have been put on notice and had a chance to investigate the fire scene and to see the product where it was last left standing just before the fire started, then that product needs to be secured, wrapped up, usually in, if it's a big product, you do the best you can in terms of shrink wrapping around it. If it's a smaller product, you basically have your expert take possession of it, make sure there's a chain of custody established, a written chain of custody established, and you secure that product in such a way that there's no question that the product you were dealing with on the day of the fire is the same product we're dealing with 2 years later in the courtroom, okay? We also want a detailed statement of the operator. The operator is frequently the key to any kind of product liability case because they're the person who was using the product immediately before the fire started. They will be able to tell you, among other things, what they were using the product for, how they were going about using it, what their experience, knowledge, training was with respect to using that particular product, okay, whether they were following a specific set of instructions that came with that product while operating that product. All those things you want because you want to make sure that the operator itself was using it correctly and was using it according to instructions. And if they were not using it according to instructions, well, is that what caused the fire, or was it the instructions themselves that caused this fire? Because he was following those instructions, and those instructions actually led to this fire starting in the first place. You want to identify who manufactured the product and where it was purchased. And the reason you want both of those, because frequently they're not the same. You have a right to, we're talking product liability here, we're allowed to bring a negligence claim against the manufacturer, okay, for having produced a defective product and having negligently produced a defective product. And we're also allowed to bring into the case the people who sold the product to whomever it is that ultimately bought it, okay, or that could be the Home Depots of the world. It could be any retailer, any wholesaler from whom bought the product originally from the manufacturer and then resold it to a consumer, okay? And the reason behind it is it's called strict liability, is that because that retailer sold a product which was already defective when it got into their possession, they are as much on the hook for this loss as is the manufacturer for having sold the product as a negligently manufactured product in the first place. So maybe, just to be clear here, two claims: negligence on the part of the manufacturer, okay, and strict liability on the part of the reseller, okay. Because strict liability, all strict liability is, it's still the negligence claim. It just eliminates the proof of negligence that the reseller made the product defective in some fashion. All right. Next, we've already talked a little bit about this: modifications, repairs, and maintenance. Is this a product which has been in the possession of your insured? If so, has this thing been modified? Have there been repairs made to it? Has there been maintenance performed on it? You want to ask your insured if those questions, and if so, you need all the paperwork which shows which modifications were done, repairs, maintenance, what have you. Okay. In addition to, if the situation, well, you also want to know who performed those modifications and repairs and maintenance. You can talk to them too as to why was this product modified after it came from the factory. Okay. What repairs were done, when, okay, and what we were trying to repair, and in fact, was the product repaired at the time it was sent to be repaired. All right. You also want the operators and service manual. We talked a little about that, because if you're going to find a potential defect in warnings or instructions, you're going to want to look at the service manual, operator's manual that came with the product to the insured at the time it was sold to them. Excuse me. Always a background consideration is the economic loss doctrine. I'm not going to cover the economic loss doctrine in much detail here, because I could talk an hour about that all by itself. Long story short, if the product itself was destroyed, okay, and nothing else was destroyed, say it's, for example, we're talking about a car that caught fire in the engine compartment, okay, that's sitting on the middle of a street, and all that burns up is the car itself, all right? In that scenario, because of the economic loss doctrine, the only claim that you're allowed to bring against the manufacturer of that car, assuming the car is defective in some fashion, would be a breach of warranty or a breach of contract type of claim, okay? You cannot bring a claim in tort, negligence, or strict liability, in other words, okay, against that manufacturer where only the car is destroyed and nothing else. However, if the car burns up, same set of facts, it's caused by a defect in the car itself, all right, and the manufacturer is responsible for that defect, if that car burns down the garage it's parked in, or the house it's parked in, okay, or burns up other property that's in close proximity to that car, then in addition to the breach of contract warranty claim, if it's available, you can then bring your tort claims to recover those damages only. Not the damages as to the vehicle itself, but the damages to the garage or the building, okay? So in the back of your mind, economic loss doctrine is always one of those considerations to think about when you discover that the product itself was the only thing that was destroyed as a result of the fire, as opposed to, you know, in the context of a car, a garage, or a building, or something along those lines, other property, in other words. Okay, next here we have a series of slides which will allow us to talk a little bit more about how product liability works and how you need to think about as many parts of the case as possible before you actually have to go and file suit on it. What you have here in front of you is a picture of a construction heater. All right, this is a case that we worked on, concluded a couple of years ago, last year actually. It took 3 years of litigation to make it go away. But the long and the short of it is, what you see here is a tube construction heater, which is it's a large construction heater. It puts out 400,000 BTUs of heat. That's enough to heat 4 full-size single-family homes. What that heater is doing, it's parked, you see, in front of a concrete structure or a block structure, okay? That block structure is the bottom of an elevator shaft for a 3-story condominium building. The reason that heater is there is because this is a construction site. This condominium building was being built along with condominium buildings on either side of it, and was one building of 36. 3 buildings burned down, okay, as a result of this fire we're looking at here. The tune of about $4.3 million. Our theory of the case was this heater caused this fire. What the heater was being used for, let me back up a step. what happened here is that the general contractor, who was actually a subcontractor of the developer, okay, was contracted to build 6 of these 36 buildings. And the supervisors in this of this contractor, site supervisors, parked this heater where you see it, okay, at the base of the elevator shaft for the purposes of thawing out 18 inches of ice that appeared at the bottom of that elevator shaft. The way they went about doing it, they parked that heater where you see it, and then they built a false wall around it made of wood, OSB board they call it, okay? The wood did not touch the sides of that heater in any way, shape, or form. That's their testimony. And even if it did, this heater is advertised as being quote-unquote cool to the touch. I have done this myself. We had a working model of one of those, and if you fire that heater up to full blast, you can put your hands on either side of that heater, okay, and not be burned, is what it boils down to. So they relied on that, parked it in this opening, surrounded it with wood, and then built a false ceiling about 10 feet up from where that heater sits, okay? Then they let it run for about 24 hours. Somewhere in that 24-hour time frame, a fire occurred and burned down this building and 2 other buildings along with it, okay? Now, here's where it gets fun. The initial thought here when we got the case was we can just go ahead and sue the subcontractor because what they did was kind of stupid. When you take a heater that puts out that much heat and put it in close proximity to combustibles, the wood frame around it and the wood 10 feet above it, okay? But we did our investigation early on, and naturally we discovered that there was a contract in place, and in that contract was waiver and indemnification language wherein the developer, our insured, basically agreed to indemnify and not sue the subcontractor for negligence, essentially, okay? So we could not sue the subcontractor. So where do we go next? We looked at the heater as a product's liability kind of theory of case and discovered a couple things, that this heater, while designed as it was, it's 15-year-old design, okay, it didn't have certain things that could have made it more safe for operators. Number one, it didn't have what was called a remote thermostat, which is nothing more than a tool at the end of a wire, all right, which would be draped into that elevator shaft, and when the temperature got to a certain point, would have shut the heater down, okay? This product came with a thermostat which was located to the aft end of the heater. You can't see it in this photograph, unfortunately. It's on the reverse. I'm sorry, yes, you can. No, I'm sorry, you can't. The thermostat that came with this heater was fixed to the machine itself. It is on the other side of that square box you see on top of the heater. That square box was not in the heated space, so that thermostat could not be exposed to the heat in the heated space of the elevator shaft. The result was this thing ran for 24 hours without ever shutting off, and the theory of the case was that the temperature got so high inside that sealed-off space between on the first floor of that elevator shaft that it actually caused the wood at the top and the sides to catch fire. All right. Now, you might still be saying to yourself, well, that's still not the fault of the manufacturer. That's still a lack of common sense on the part of the subcontractor for having put this heater in such close proximity to wood. Well, you would think so, okay? And it was I'll be honest, that was my first inclination as well, all right? But here's where it gets fun. This heater, its instruction manual, didn't reference a situation like this, okay? Didn't say it was bad to do it, didn't say it was good to do it. Didn't warn that its thermostat needs to be exposed to the heated air that it's being heated in order to operate, to shut down, to turn off. The only warning that came with this heater was on this label that you see in front of you, okay? And it basically says, for your safety, do not use this heater in a space where gasoline or other liquids having flammable vapors are stored or used. Not very compelling, not a warning so much as an instruction, if you will, okay? That maybe if you put this 400,000 BTU heater that puts out 450 degrees in temperature in close proximity to gasoline or something, all right, that it might cause an explosion, all right? That's about as urgent a warning as this whole product came with. Now, you still might say, commonsensically, how can you hold the manufacturer of this product responsible, or for that matter, the seller of this product responsible for a loss where it appears that these two contractors, these subcontractors, just basically did something that commonsensically didn't make sense to do. Why would you put this heater that puts out 450 degrees of temperature in such close proximity to wood, which burns at about 423 degrees? Okay, this is why. You see here an example of another heater, not made by the original heater. The blue one you saw was made by a company called SureFlame, and that heater was marketed by a company out in Indiana called Heat Wagons. Heat Wagons maintained the website, and this picture appeared on their website. Okay, this picture appeared on the website. What you see here is a heater, which I discovered later on was much larger than our 400,000 BTU heater. This heater, in fact, was 1,500,000 BTUs of heat this thing put out in terms of temperature, or in terms of BTUs. It felt much, much, much bigger heater. Nevertheless, what you see in front of you here is that heater sitting on top of wooden pallets, close proximity to wood, and its nozzle, as you can see there, is placed inside other wood products. That's plywood surrounded by and held together with 2x4s. And you can see, you can almost see, that this heater sides are in fact touching that wood that you see there. Okay? So, the moral of the story, if you will, is this heater came with absolutely no warnings about, hey, if you don't keep your thermostat exposed to the heated area, it's never going to shut off, okay? Had no instructions in that regard, number one. So the theory is these two subcontractors basically on their testimony was, we set the heater to 59 degrees and we expected it at 59 degrees to turn off. We only needed to melt ice. We didn't need to burn down a building. That was essentially their testimony, okay? Combine that with the fact that the way this product was used by these two contractors was not only foreseeable, but recommended by the distributor, the sole distributor of the SureFlame heater in the United States, okay, on their website. This is a good use of their machine, okay, or machines like it. That was enough to get us a nice recovery, okay, on a theory of product liability, where the machine in and of itself didn't actually, it was dangerous and effective because of what it was. It put out lots of heat and put out an open flame. But there was no warnings and no instructions from either the manufacturer or the seller of that product, which says the way in which these two guys set this thing up was the wrong way to do it, and there was a risk of fire, injury, and property damage as a result. And in fact, remember I told you earlier about the 3-foot but 5-foot poster I'd like to have pictures of in front of the jury. Now, this thing settled before it got to the jury, but trust me when I say this picture we're looking at right here was number one on my hit list for 3x5 blow-ups that I wanted to put in front of the jury. Okay? So when you look at that example there, that case, you have a situation that already discussed or takes into account several of the topics we've already talked about. Okay? Number one, we have a subcontractor who we believe was initially negligent and caused this fire. And it's probably true, too. Okay? In fact, it was definitely true. They were contributory negligent in causing this fire in some respects. The question is to what percentage. Either way, we discovered early on there was a contract in place. That contract did have anti-subrogation language in it. So we discovered very early on that we were not able to go ahead and seek recovery from that third-party contractor. We went on to look into the possibility of a product's liability case and whether we could bring a claim against a manufacturer or a seller. In this case, we brought them against both under theories of negligence as to the manufacturer and negligence as to the seller, too, in addition to strict liability claims as to both. And we were able to bring these claims based upon the design, because there was no remote thermostat that went with the machine, which would have exposed the thermostat to the heated space, and then strict liability as to both because the product was defective as a result of that, and negligence as to both because neither one of them warned or provided proper instructions to would-be users of this product that the way they use it in this fashion could cause a fire. And then when it comes to the actual distributor themselves, they were negligent because not only did they not advise against or warn against using this product in this fashion, but in fact they recommended using this product in this fashion by virtue of their advertisements on their website. All right? Okay. Now, early on I stated when you're talking about products liability, you need experts. You cannot prove a case without hiring an appropriate expert to opine on the cause of the fire and the methodology behind the cause of the fire. So when do you hire an expert? Again, your origin and cause expert should be hired pretty much immediately, in my opinion. All right. When to hire an expert to talk about cause in detail? Sometimes it's immediate if you already have a suspicion of it's an electrical fire, okay, or it's a gas fire. All right. You know, if you have that kind of information from the outset, then it's safe to hire an electrical engineer or a mechanical engineer who specializes in gases and HVAC and furnaces. At the same time, you retain your cause and origin expert. Okay. Be that as it may, sometimes you're not going to know what's going on from the outset. So let your cause and origin expert, who's mostly origin, by the way, get an idea of what's going on, where the fire leads him to an origin, and then make a determination. You know, for example, if he believes that the origin of the fire is the furnace in a house, well, you're in that situation. You're probably going to need a mechanical contractor who specializes in HVAC and gas-fired appliances. Your experts, as far as engineers are concerned, they run the gamut, but the most common ones you're going to see are electrical and mechanical. Sometimes run into chemical where you have a situation where you believe that certain chemicals, maybe some petroleum products, things of that nature, caused fire spread, made a fire much larger than it would have been but for those chemicals being what they are. Sometimes a civil engineer is helpful. I've never really had an occasion to use them myself, but they are available for that purpose. Accident reconstruction and human factors. Accident reconstruction in the context of a large fire loss case, you're not going to see all that often. More often you're going to see that in the context of a motor vehicle accident type of case. Human factors is different. Human factors experts, that you're going to see here. We hired a human factors expert in the construction heater case to talk about why it's perfectly logical and in fact expected, let alone reasonable, that these two subcontractor supervisors set up this heater in the manner in which they did. Okay, the whole idea behind human factors is to overcome, I don't want to call it a presumption, maybe it's an assumption is a better word, an assumption by many people, myself included to one extent or another, that these two subcontractors just didn't exercise an appropriate degree of common sense. Okay, we all apply common sense to everything we do every day, and it's easy to say, well, I wouldn't have done that. Okay, in the context of this heater as an example. Okay, an appropriate human factors expert has the ability to burn through our presumptions and our assumptions with respect to common sense, among other things, and say, and suggest essentially with an opinion that, hey, you know what, these two subcontractors, they did exactly what they were supposed to do given the presentation of the problem, the experience that they had, okay, the instructions that came with the machine itself. All of that was perfectly logical, all those are perfectly acceptable factors in leading to the logical setup of the way they set this machine up. All right. Where to find appropriate experts? There are tons of expert databases out there and referral companies. Okay. Truth of the matter is, my suggestion is call someone like me, a subrogation attorney. We have our favorites. I'm not going to lie to you. We like certain experts more than others. The expert community and the fire investigation community is a rather small one, and it's very easy to determine who are the better experts and who are not the so good experts, shall we say. Okay, and again, we have our favorites, and the reason we have favorites is because the experts that we like to use, who we consider favorites, are very skilled in their training, knowledge, and experience, and sometimes more importantly, they are able to boil down a theory of the case and an opinion into terms which are easily understood by the random selection that is a 12-person jury. Okay, they can speak to a jury on a one-on-one level and convey their opinions in such a way that they're easy to understand, and it makes the ability to prove your case that much easier. Being an expert and choosing an expert, know what it is that you need is what it comes down to. All right. In any fire loss case, like I said, you need a cause and origin person. Okay. But knowing when you need an electrical, mechanical, or chemical, or civil engineer, let alone a human factors expert, okay, that's something else again. To some degree, you have to know what it is you're going to need once you've been told by your origin and cause expert, hey, I got a situation here where this fire leads back to this little wall socket in the in this building. All right. Well, you as the expert should know that you as the adjuster should know, investigating the case, that your electrical engineer is probably your most logical choice for what it is that you're going to need to prove the cause of the fire. And then budget and cost effectiveness, which leads us to the next slide. When you select an expert, think of it in terms of this way, and actually I can't use this term anymore. We used to call it the Lexus versus the Hyundai type of experts. However, in the last few years, Hyundai has come on strong and makes a pretty good product nowadays, so we have to change the slide to be something along the lines of, maybe it's the Lexus versus the Hugo, if you remember the 1980s Yugoslavian vehicle. In terms of those are the kinds of experts you're dealing with here. Which expert do you want? Do you want the Lexus kind of expert, top of the line, high quality, knows what he's talking about, can convey the message in the best way possible for a jury? Or can you settle for, and that's the best way of thinking about it, can you settle for the Hugo kind of expert? Maybe your loss is not that much money, less than $10,000, okay? Maybe an expert who is not anywhere near as well versed as your Lexus kind of expert, but costs a whole lot less just to produce a report on the cause of the fire, okay? It's suitable in the context of a $10,000 or $8,000 or $9,000 case, because all you need is a report to present to a third-party insurance carrier to say, hey, listen, I got an opinion that says this fire was caused by this machine produced by your insured, okay? That's the context, and when you go about selecting from a purely price point, if you will, okay, Lexus versus the Hugo kind of expert. Because I'm not going to lie to you here, in the Lexus kind of expert, and we used 2 Lexus kind of experts in that heater case. That was a $4.3 million case, and those expert costs were pushing $250,000 when it was all said and done. All right. Breadth of training and experience. It's easy to find out. Any expert who is good at being an expert is going to have a curriculum vitae, and it's a simple task just to ask for it, because they will readily give it to you when you're considering hiring an expert, and to see what's on it and see where they got their training, knowledge, and experience, and moreover, how they're held in the community. Most CVs nowadays will show publications that these experts have put out, where they've spoken, things of that nature. Will the expert's opinions hold up in court? Depending where you're practicing, perhaps it's federal court where the Dalberic rules and regulations apply. In that situation, the expert has to be able to testify on how his work is peer-reviewed. He's going to be able to testify on what learned treatises he or she was using when coming up with his opinions. So other jurisdictions, of which Wisconsin was one until about 2 months ago, there is no such standard like that. You could have a shade tree mechanic who works on cars on the weekends serve as an expert witness just by virtue of the fact that he has experience and knowledge, which allows him to make an opinion with respect to why a car is broken or not broken, as the case may be. Reports, key thing when dealing with experts is this: all expert reports all experts' files, everything in them is discoverable, okay? Meaning that once we disclose an expert in the course of litigation to the other side, to the defendant parties, okay, they will almost certainly respond with a written discovery request saying, we want your expert's entire file as it relates to this case and their investigation and opinions, okay? And they'll get it. So what that means to you is this: whatever it is that you don't want in that expert's file should not make an appearance in an expert. Don't give the expert an opportunity to put it in his file. In other words, if you communicate with the expert, all right, and you believe you have sensitive information that you want to communicate to that expert, use the telephone. Don't use email, okay? Because those emails will be printed by the expert and they will be preserved and made part of the file. No preliminary reports. I typically would tell my experts, folks, I don't want any reports prepared, none whatsoever, unless and until a court or a judge says I have to produce it as a matter of discovery, okay? And the reason for that is very simple. If you get a preliminary report where the expert has done a quick investigation, has talked to a couple of witnesses, looked at the evidence of the fire, whatever the case may be, okay, and has very quickly thrown together a 3, 4, 5-page report, which really is mostly photographs, and then offers some quick opinions at the end of that report, which are not really, he's not had a chance to really think it out the way he needs to think it out or conduct the testing that he or she might want to do to ensure that the product that he thinks caused this fire, in fact, did cause the fire, and why. All right. If you have an expert produce a quick report like that, the problem you have at the end of the day is that 2 years down the road, once all additional testing has been done with all parties present, once all sorts of written discovery has transpired where information which may have not been available to the expert 10 days after the fire is now available 6 months after the fire, okay? What you've done is you've boxed that expert into a position which he may not be able to defend at this point in time in light of this new evidence or in light of subsequent testing, okay? So the theory is, why put your expert in a position like that where he or she has to defend a bad report just because what it was that he or she needed to make a complete report could not be accomplished until 6 months or 7 months or a year down the road while litigation was ongoing, okay, and new evidence is being discovered. So rule number 1, I tell my clients, no reports until the judge says you have to produce them, okay? All right. Fire and explosion cases, again, investigation is the key, and we're talking cause and origin and investigation protocol. The investigation protocol is run is every expert, every cause and origin expert is familiar with NFPA 921. This provides the methodology and the steps that are to be taken by any origin and cause expert when investigating how a fire originated. Okay. If you have an expert who doesn't subscribe to 921, get a different expert, because every other expert you come and encounter, okay, including all those defense experts, are going to refer to 921, and that is the standard in the industry for investigating a fire. First origin, then cause. What I said earlier about hiring an origin cause expert and then an engineer later on, that's what this all comes down to. We have to determine where the origin of the fire is first, then figure out why the fire started. I'll give you an example here. I have a case in California at the present time involving a $6 million truck stop along I-5, and we initially thought it was an electrical problem. We specifically thought that a neon sign that was positioned outside of the building, mounted to the building but outside of it, had just been installed and serviced by a neon sign company, and all signs initially pointed to that sign, no pun intended, as being the origin of the fire. However, once we got an investigation rolling and we had our origin and cause people out there, and of course the sign company had their origin and cause people out there, and we already suspect electricity, so we had an electrical engineer out there as well. Well, at the end of the day, nobody could establish a firm origin for the fire. And without that origin, essentially that electrical engineer was worthless, because without being able to identify about where the fire came from, we had no way of knowing what was at the basis of that origin to determine whether, whether it was an electrical problem or an appliance or something else. Fire spread cases, these are cases where you're alleging against a third party or third parties that a fire occurred. Their actions or their product may not have started that fire, but their actions and their products may have allowed that fire to get much bigger than it would have but for that product in the first place, okay? Those are situations, your cause and origin experts should be able to opine on a situation like that just as much as just talking about how the origin of the fire occurred in the first place. Fire response liability, I'll give you another example here. I'm working a case in Milwaukee as we speak. It is a property case only for me. A duplex house, which our insured rented out to low-income families, okay, exploded as a result of a gas main leak out in the street. And I have the property case only. However, other attorneys are representing the two sets of tenants in that duplex house, okay? In that scenario here, the question of whether there's a fire response liability, the facts are the gas leak is first reported by somebody calling it in at about 2:05 in the morning. It wasn't until almost an hour later that, and gas was everywhere. It was very prevalent. Police reporting it, fire departments were reporting it, everybody was reporting it in that from 2:05 on. It was a big gas leak. It was almost an hour. It was 2:55 in the morning, so 50 minutes later on, that this house ultimately exploded. Okay. However, there was no evacuation order put into effect, and nobody came. Well, the police department came around and knocked on people's doors, basically to inquire if they smelled gas, but nobody went ahead and evacuated residents from the area where the gas leak was identified as where the origin came from. When the building exploded, okay, the gas company's on the hook for this. There's no doubt about that. All right, we have, and there's two theories of the case here. One is, number one, why the gas main broke in the first place. It turns out it was lack of maintenance. This was a very old gas line. It should have been replaced 20 years ago, let alone it was a 40-year-old gas main. So that's number one. And number two, whether and to what extent the failure of the fire response, okay, or the gas response on the part of the fire department or the police, and by extension the city of Milwaukee, all right, these damages could have been mitigated or made reduced. Well, here's how it played out. Because I only had the property side of the case, there's no reason for me to go ahead and bring a separate claim against the city for failure to respond to the gas leak. All right, it would not have mattered whether the people inside those buildings had been evacuated 10 minutes, 20 minutes, or 45 minutes before the actual explosion occurred. Our building would have exploded nonetheless. Okay. However, the attorneys represent the two tenants in that building, okay, in addition to the basic maintenance liability question that I've brought, they did, in fact, bring a lawsuit against the city for failure to evacuate issue an evacuation order so that the injuries that were caused or sustained by their clients were prevented, essentially, okay? Sprinkler systems, burglar and fire alarms, to some extent that's sort of like a fire spread case, okay, where fire starts and there's a sprinkler system in place, but for reasons that are determined to be for reasons unknown or known as the case may be, the sprinkler system did not operate. And as a result, instead of the sprinkler system suppressing the fire and minimizing the damage, in fact, the whole building went up in smoke instead, okay? So, in a situation like that where, say you can't even prove how the fire started, maybe it was just a pure accident, you may still be able to go ahead and bring a cause of action against the sprinkler company who installed and or maintained the sprinkler system because it didn't operate as it was supposed to operate, and the fire, which was already in place but was made a whole lot worse, was the result. All right. Again, eliminates other causes. We've already talked about that, and we're running a little close on time now. Limits of liability. We've talked a little bit about that as well. Let's move on here. Electrical fires. Okay. Electrical fires, my experience has been that more often than not you see electrical fire almost all the time, more often than any other kind of fire. That's been my experience. Now, I'm sure other people have had more experience with gas fires and things of that nature, but when it comes to electricity, I seem to get my lion's share of the darn things. So, when you're investigating electrical fire, obviously we've already talked about this, but you need an electrical engineer to talk about how electricity works, how this building was wired, and why this fire was the result of electricity in the first place. Electrical wiring, electrical equipment and appliances, these are the things that we are looking at when we are examining whether an electrical fire. Let's be honest here, everything we do nowadays depends on electricity. Everything that we have in our houses depends on electricity. Electricity makes our society go. That's what it boils down to, okay? And for the most part, electricity is a very, 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 very safe utility, and not much happens. But on occasion, electricity, when left to its own devices and given an opportunity, will cause an awful amount of damage if not controlled the right way, okay? So when we're talking about an electrical fire, it's tricky because it's tricky because the situation with electrical fires is they tend to destroy most of the evidence of the cause of the fire, if you will. We're talking wires and whatnot, and they tend to disintegrate when exposed to extreme heat. Regardless, when we're talking about electrical fires, we want to identify certain things. With the new construction, obviously we want to identify electrical contractors who built the building and whether they wired the building the right way. We also would like to hear about any unusual electrical activity. For example, maybe the transformer on the block where this building burned down exploded in the hours leading up to the fire itself. Maybe that exploding transformer caused a surge of electricity to go through these buildings, and this building could not handle that surge, and the fire was the result. In a situation like that, there's nothing that was done wrong by any contractor or any kind of electrical installer, but the utility that maintained that transformer may be on the hook for liability in this case if it's proven that that transformer should have been maintained or serviced in some other fashion than what it actually was. Notice and preservation evidence, we've already talked about that. And identifying defendants and third parties, we've already talked about that as well. In the context of electrical fire specifically, again, if it's electrical contractor situations, new construction, something along those lines, or you have reason to suspect that an electrical contractor has just serviced the outlet or whatever it might be that now serves as the origin of the fire, oh yeah, they're definitely on should be put on notice of the fire, okay, and inspections and what have you. We're talking about a situation where maybe an appliance caused the fire, okay, a hair dryer, computer screen, stove, electrical dryer, whatever the case may be, all right, that can be tricky in terms of identifying potential third parties. Generally speaking, it's not that great a task or not that hard of a task to identify who actually manufactures the overall hair dryer or overall clothes dryer, okay? It's where we suspect that a component within those products may have caused or failed in some fashion to have caused the ultimate product to fail and burn the building down. That's where we have to identify those defendants who manufactured those particular components in that hair dryer or in that clothes dryer, and they need to be put on notice too. If nothing else, by extension, it's another pocket to look at towards recovery, okay? And in the case of Wisconsin, we have an obligation to to bring them into the lawsuit regardless, by rule. Okay, obstacles to subrogation, property subrogation, made whole doctrine, all right? Many states have a version of made whole. Wisconsin is the king of made whole, as the case may be. I'll give you an example I'm dealing with right now. I have a case that I was in suit. We settled the case. It involved an electric garage door opener. That electric garage door opener shorted out, a component inside shorted out, and caused our insured's garage to, it's a commercial garage, to basically burn to the ground, is what it boils down to, all right? The manufacturer, we settled with the manufacturer of the garage door opener. The problem, however, is that the insured, truthfully, was way underinsured to the tune of about $100,000. All right. Our own claim was only about $65,000, but then again, it's only $65,000 because the insured was underinsured. That said, because we are in Wisconsin and because made whole is a very, very strong tool for plaintiffs in this case, in this state, we settled with the contractor, or strike that, with the manufacturer of the garage door opener. So did the insured for another $50,000. So he's still about $50,000 short on his total loss. Therefore, he's not been made whole for his total loss. And ordinarily, Wisconsin says, well, in that case, you as the carrier are not allowed to make a recovery of any kind until such time as your insured has been made whole for all his uninsured losses as well. All right, that's the underlying law in the state of Wisconsin. Recently, in the last couple of years, there's been a new case called the Golke Brothers case, where made whole has been weakened a little bit, shall we say, is the best way to describe it. And the long and the short of it is, it recognizes, the court in the Golke case recognized the fact that when we're talking about a situation like we have, what we all deal with here, where we have a third-party subrogation action in a products liability case, okay, and we're going after a third-party defendant who has gobs of money, Okay, they have tons of insurance, or they're self-insured to millions and millions of dollars. Okay, in that scenario where our claim and the combined claim of the plaintiff is less than $200,000, why is it? You recognize the theory that why should we have to give up our $50,000 settlement, okay, to the insured just because he was not able to press the manufacturer of that garage door opener for his full amount of settlement, okay? Chamberlain garage door openers, they were self-insured to $20 million. There was more than enough money to go around. So with that in mind, what GOLKI stands for, it recognizes the fact that we as the carrier should be able to settle with the Chamberlains of the world who have lots of money to go around and more than enough to settle all claims, okay? And where the insured, in this case, while he was underinsured, there's no doubt about that, but he had an opportunity to settle the claim for his whole amount, his whole claimed amount, but did not do so for whatever reason, okay? In that scenario here, we should be allowed to keep our $50,000. Well, long story short, we settled the case, they settled the case. The counsel for the insured in that case, as we speak, is drafting what's called a motion for a Rhines hearing, where the question of whether his client was made whole will be brought to bear in front of the trial judge. Neither one of us expects the trial judge to rule the way we want him to rule, and we fully expect this case to be appealed to at least the Court of Appeals in Wisconsin to get a more firm definition of what GOLKI means. So we'll see how it goes. The point is, made whole is a consideration because you have a situation where your insured is saying, "Hey, I'm not being made whole for all my losses. I might hold you as the carrier responsible, under a bad faith claim for not paying all that I think I'm entitled to get. Number one, or in a situation like I'm dealing with in the Chamberlain case, okay, he just was underinsured and he's claiming that we are not allowed to make a recovery. All right." Economic loss doctrine we talked about, statute of limitations, always a consideration. One of the first things you should do in your investigation is determine when the statute of limitations runs for property. Some places it's 3 years, some places it's 2 years, some places it's 6 years. Know the state that you're working in. Statute of repose. Statute of repose is a version of a statute of limitations. It applies predominantly in our cases to products. Basically the law recognizes that a manufacturer does not have to insure forever for all time that a product is going to be made free of defects for its entire existence. There is a limitation on that. Typically, it's anywhere between 6, 8, 10, 12, or 15 years. Wisconsin just recently put in the law a statute of repose for 15 years on products. Governmental liability, we talked about that already, somewhat in terms of notice, in terms of what their exposure is. For example, what you're looking at in terms of what their maximum exposure to liability might be. In that gas explosion case I was just telling you about a moment ago, the city of Milwaukee, regardless of whether they're found negligent or not as to those tenants' claims, the most they can be held accountable for is $50,000. So even though they may be claiming $1 million or so. Subrogation waiver, exculpatory clauses, we talked about those in the context of subcontractors agreements. Landlord, tenant, and fly co-insureds. Depending on what states you're working in here, you may have what's called the Sutton Rule to consider, meaning essentially that if a situation arises in a residential tenant-landlord situation and it's determined that the tenant, by whatever action, was negligent in causing a fire, because of the Sutton Rule, you may not be allowed to subrogate against your tenant because the rule says that the concept is part of the lease, the rents that are paid by the tenant to the landlord, aka your insured, are supposed to go towards the purchase of insurance by the landlord to cover fire losses. Okay. Obstacles, including insurance cooperation. I have to tell you, when insured is not being cooperative and in helping you investigate a fire and the causes for a fire and potential third parties, it makes recovery that much more difficult. All right, we're almost out of time, about 3 minutes. I think I can cover spoliation, and I think that's the last thing I have to do today. We talked a little bit about spoliation. Basically, what it says is true. Intentional destruction, mutilation, alteration, or concealment of evidence, okay, undermines the truth-seeking function of the judicial system. Long story short, defendants who are being accused of having caused a fire for whatever reason will want to look at what you claim to be the cause of the fire, whether it be a machine, whether it be a person, whether it be an instrumentality, whatever it might be. And if you do not preserve that instrumentality of the fire, okay, they will almost certainly make a spoliation claim, alleging essentially that you intentionally destroyed the evidence, altered it, or concealed it, okay? The purpose of which was to basically make your case stronger, while at the same time prejudicing them in their ability to defend against that case, okay? And the result is that they're looking for a dismissal, or at least a negative instruction to a jury, saying essentially that you did wrong by them, and that we should be held accountable for it in whatever fashion the jury deems fit. So, to prevent a spoliation claim, preserve the scene. We've already talked about this. Put notice to all potentially interested parties. I'm not kidding when I say I like a shotgun approach. Anybody who I think might be interested in this case should be brought on board. Schedule a joint inspection to allow all parties to participate. Preserve that key evidence. Make your chain of custody. Establish a protocol for investigating the scene itself involving all the potentially interested parties. Make sure they all sign off on it, okay? And in spoliation, like I said, if one or all those things is not done, what a defendant is typically looking for is dismissal or an adverse inference in the form of an instruction to the jury. Okay, so it's our last slide. And if you come away from this presentation with anything, these would be what I would recommend, okay? Subrogation is an investment, all right? Meaning that the work that you do in the early parts of your investigation and improving your case, okay, setting up your case for success, all right, that's the investment we're talking about here. That work done early on will make my job as the subrogation attorney that much easier. Take your investigation seriously, do what has to be done to prove up your case. Tag large losses for additional investigation. You can all establish what criteria you want, but let's be honest here. If you have a case at 6 figures or better, it's worth a second look to look at it and see if there's a possibility that maybe you can go after a third party and subrogate against them. All right. Strive to be cost effective. Don't beat yourself against a rock. For example, in the construction defect realm, if you get the subcontractor's agreement early and there's indemnification and waiver language in that subcontractor's agreement, well, you can't subrogate, but at least you know, and you're cost effective because now you can go on to move on to more better things that pay better. Okay. Who else owns this loss? We're talking about the insured themselves more often than not. Okay, or the tenants, for example, in my gas explosion case. Those are folks who you may have to share in the in the investigation, number one, and maybe in the available funds to cover all losses, number two. And number three, and the final thing here, think subrogation. When it comes to adjusting a claim, I would keep subrogation in the back of your mind as much as anything else is when you're adjusting a claim, because at the end of the day, it can be a good money maker for the carrier. Okay, so that's all I have for today. I'm looking at questions now. Let's see. I did have one question here. I was talking about spoliation at the time, it looks like, but I think there's a question regarding notification, 120-day notification. Is this per state statute, federal statute, or both? When it comes to Wisconsin, that's what I was referring to. That is pursuant to state statute. There is a federal statute that's applicable to claims against the federal government as well. I believe, don't hold me to it, but I believe it's 180 days. Okay, but again, it's every state's a little different. Every state has their time limit, if you will, for putting on notice of a claim. All right. Okay, it looks like I don't see any other questions having being asked, so it is about 3 minutes after 12. That will conclude our presentation for today, and I thank you for your attention. Have a good day.